Thank you. Sarah and I had talked about her going before me, but I think partly because I was introduced, partly because I just got off a plane. I'd like to get to the hotel. I'll speak now. And what I'm going to talk about is why seek a legal remedy for genocide. Now, seeking a legal remedy for genocide can be frustrating. Though the term genocide is often used politically, it is rarely successful legally. And nonetheless, the effort is worthwhile, despite the difficulties. Justice for genocide is not necessarily the same as criminal prosecution, conviction, and sentencing for genocide. Justice for genocide can take a variety of forms. There are three basic remedies for genocide available: prevention, prosecution, and civil liability. Prosecution is specific, prevention is generic, and civil liabilities can be either. Civil liability is the form of justice available under the Genocide Convention. If one state party to the Genocide Convention brings another state party to court for violation of the convention, the court does not hold a criminal trial assessing accusations against individuals. Rather, it's the behavior of the state itself which is assessed according to civil liability standard. Justice can mean trial without punishment. That happened in Rwanda after the genocide through Truth and Reconciliation. The Tutsi victimized community, though through military intervention, replaced the government of the Hutu genocidal killers and prosecuted the planners of the genocide. Local community or Gagaka courts prosecuted others involved in the genocide, but either gave low sentences or issued community service orders or allowed prisoners complicit in the genocide but not involved in planning to return home without further penalty, provided the accused confessed, was repentant, and sought reconciliation with the victim community. Justice can also mean truth and reconciliation, even without trial. This is what happened in South Africa at the end of apartheid, other than for the worst violations for which there were prosecutions. The victims, the Black majority, though sorely treated for the most part, remained alive, formed the government of South Africa, and were able and willing to reconcile with their perpetrators in exchange for an acknowledgement of truth of what happened. Justice can also take the form of people's tribunals. Even when the law is not available, the search for justice is still a worthy pursuit. People's tribunals are viable options when there is no formal legal recourse. An example is the Permanent People's Tribunal on Sri Lanka, held in December 2013 in Bremen, Germany. That tribunal concluded that there was a genocide in Sri Lanka directed against Elam Tamils, which reached its climax from September 2008 to May 2009 with the Molivakal extermination, which had a reported almost 150,000 victims unaccounted for and more than 70,000 people feared dead. That tribunal could not punish the perpetrators. Nonetheless, it provided an evidentiary record and an independent determination of guilt. Justice can also mean prevention, as we've heard. Because of legal difficulties, attempts at prosecution and civil liability raise the question: why not seek to prosecute or obtain a civil judgment for another wrongful act where a judgment poses less legal difficulties? That question does not arise for prevention. The issue of prevention arises not just before a genocide occurs, but also while it is occurring. Preventing a continuation of genocide is a prevention of genocide. Prevention of genocide, while it is occurring, points to different forms of genocide: hot and cold genocide. Hot genocide is the immediate unleashing of genocidal acts. Cold genocide is slower, with the genocidal acts taking place gradually over time. Hot genocide, once it begins, is hard to stop because of the speed with which it occurs. Cold genocide allows for more scope for prevention. Moreover, it is not necessary to conclude that what is happening is genocide to engage in prevention techniques. These techniques can be undertaken without consensus that there's a genocide in progress. An example is the mass killing in China of prisoners of conscience for their organs. The numbers are sufficient to justify a conclusion in conjunction with evidence about intent that there is an ongoing full genocide of Uyghurs and practitioners of the spiritually based set of exercises Falun Gong. Yet such a conclusion is unnecessary to justify setting in place mechanisms to prevent complicity abroad in this abuse. These mechanisms, such as prohibiting health insurance coverage of transplants in China, denying training to transplant professionals who intend to engage in transplantation in China, prohibiting complicity in organ transplant abuse abroad, and so on, could be put in place even without a formal institutional conclusion that the abuse in China amounts to an ongoing genocide. The search for justice for genocide can continue long after the genocide has taken place, even after all the perpetrators have passed away. Over time, the search for justice becomes an effort to release the records. Perpetrators seek not just immunity, they also seek anonymity. After they are gone, their networks and apologists continue to seek anonymity for them. The effort of disclosure need not be legal, but often it has to be. Otherwise, the records are either destroyed or kept secret because of generic exemptions. The United States Congress, for instance, enacted in 1996 the Nazi War Crimes Disclosure Act. The act did not require a blanket disclosure. Rather, it made the test to meet to invoke exemptions to disclosure far more difficult than they had been, and set up an expert committee to apply the new tests, document by document. The effort, completed in 2007, 9 years later, led to the disclosure of millions of pages of documents. Disclosure of the record showing an incomplete genocide justice effort is a form of genocide prevention. We can avoid repeating the mistakes of the past only if we know the past, and we can know the past only if there's a full disclosure of the record showing the past. Yet another form of justice for genocide is legal action against incitement. It's pretty straightforward to determine whether an act of genocide occurred. The legal difficulty is establishing the intent. However, when it comes to incitement to genocide, determining whether there's incitement is not so straightforward. Incitement to genocide does not necessarily come in words accessible to outsiders. Often incitement takes the form of circumlocutions, trigger words, references known only to locals. Take an example, again, the genocide in Rwanda. Leon Mugesera was ordered deported from Canada for advocating genocide against Tutsis. Part of his discourse, on which the deportation decision was based on this. Mugesera referred in a widely disseminated speech to a conversation he had with a Rwandan Patriotic Front sympathizer, in which he said, Mugesera, I continued by explaining to him that his home was in Ethiopia, that we would find a shortcut, that is, in Naya Barongo River. Well, what does that mean? In order to appreciate this statement, its advocacy of genocide, there are a few things that a reader or listener would have to know, which are not obvious just from reading the statement. In 1959, the Tutsi monarchy was overthrown by a Hutu-led elite. In 1990, the Tutsi-led Patriotic Front launched an invasion of Rwanda from Uganda. The ruling party in Rwanda, of which Mugesera was part, viewed the Tutsi families who remained in Rwanda as potential recruits for the Rwandan Patriotic Front. They propaganded a racist anti-Tutsi ideology, referring to Tutsi as foreigners who had immigrated generations ago from Ethiopia. The Naya Barongo River flows from Rwanda to Ethiopia. It's not navigable all the way from Rwanda to Ethiopia. There had been a massacre of Tutsis in 1959 when those killed had been thrown into the river. Mugesera was calling on Hutus to kill Tutsis and dump them into this river. Other genocide justice efforts do not raise countervailing rights. However, engaging justice against incitement to genocide does require consideration of a countervailing right, the right to freedom of expression. There's no hierarchy of rights. Generally, when rights conflict, a balancing exercise is necessary, giving priority to preventing the greater harm. When it comes to the right to freedom from incitement to genocide and the right to freedom of expression, incitement to freedom from genocide, incitement to genocide is the greater harm. So any legal effort to prevent that incitement should prevail. Justice for genocide creates an independent determination of rights and wrongs. Justice provides an evidentiary record of the crimes. Justice distinguishes unequivocally between victims and perpetrators. Justice makes clear that the victims are not those who are members of the victim group, but all humanity. Justice often occurs in the context of, or genocide often occurs in the context of armed conflict, where the combatants for the opposing sides each have competing narratives. Each side has a tendency to blame the other for a variety of wrongs. Justice sorts this all out, distinguishing between the true and the false, the guilty and the innocent. Justice for genocide is never just about one genocide, the genocide past. It is also about potential future genocides. Justice for past genocide is prevention of future genocides. Impunity is an invitation to repetition. Justice is a warning. Much of what can be said in favor of justice for genocide, one can say about justice generally. However, there's one aspect of justice for genocide that is specific. Just as genocide involves the intent to destroy the group targeted in whole or in part, justice for genocide helps to preserve the group in whole or in part. Members of a group victims of genocide are going to support efforts to achieve justice for the genocide of their group. Efforts to promote justice for genocide generates cohesion of the targeted group. Justice for genocide is an antidote for group destruction. It contributes to unraveling that destruction. Obtaining justice does not necessarily follow from seeking justice. Justice for genocide is a particularly difficult form of justice to achieve because the obstacles to access to justice are so great. Yet the exercise is worth the effort, even if the result is never achieved. The very effort to obtain justice is a warning to the perpetrators. As well, the effort to obtain justice leads to awareness both of the mechanisms and the standards. It's easy enough to utter the word genocide. However, to gather together the facts and law necessary to meet the legal standard is another matter. Anyone who wants to make a case for genocide should make that case by attempting to invoke the requisite mechanisms. Making that effort allows the proponents of genocide to present the case for genocide, not just in the mechanisms involved, but anywhere. Thank you very much.